This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why, at least in Texas and other states, requests for admissions are deemed admitted if not responded to within 30 days. And it takes not even a court order to make that a fact for the case. So allowing admissions to be deemed admitted will invariably defeat the plaintiff's suit or the defendant's defense. Lynette Januzi appealed from the trial court's order granting summary judgment against her and in favor of American Modern Property and Casualty Insurance Company, AMCI, and Melissa Ann Workman. She asserted the trial court erred in considering deemed admissions and that there is more than a scintilla of evidence to support her claims. In Lynette Januzi v. American Modern, a August 29, 2024 decision of the Texas Court of Appeals, the Court of Appeals applied Texas law. In March of 2019, Januzi obtained an insurance policy from her agent, Workman, through AMCI. The policy had a $75,000 sublimit for water damage. She had a water damage claim, and over a period of time, AMCI issued additional payments to pay contractors and various damages, making the total disbursement of funds to Januzi equal to the $75,000 limit. On January 22, AMCI notified Januzi that the last payment constituted the balance of the water damage limit. Januzi took issue with the $75,000 water damage limit, claiming she was unaware of the sublimit. She further claimed that AMCI failed to adequately evaluate and pay her claim. Januzi also believed that her agent failed to provide a policy providing sufficient coverage and that there was a conspiracy between the agent and the insurance company to underpay claims. As part of the discovery process, AMCI and Workman sent Januzi requests for admissions, and although Januzi responded to other discovery requests, she did not respond to the admissions request. In November, AMCI and Workman filed a motion for summary judgment emphasizing that Januzi failed to respond to the admissions and they are considered deemed admitted. Ultimately, the trial court granted the motion for summary judgment and dismissed Januzi's claims. In Texas, once an action is filed, a party may serve written requests for admissions that can encompass any matter within the scope of discovery, including statements of opinion or of fact or of the application of law to fact. If the opposing party does not serve responses to the admissions requests within 30 days, the matters in the request are deemed admitted against the party without the necessity of a court order. Withdrawal of deemed admissions is permitted upon a showing of good cause, but Januzi has yet to request the deemed admissions be withdrawn or admitted. Because the requests for admissions were attached to the motion for summary judgment, the trial court could properly consider them. The deemed admissions were the controlling evidence before the trial court at the hearing on the motion for summary judgment, and the court could not properly have considered affidavits that attempted to controvert those admissions. In their motion, AMCI and Workman specifically relied on the following deemed admissions. 1. Admit that you signed the application for insurance. 2. Admit that you authorize and approve the insurance coverage amount stated in the application for insurance. 3. Admit that you were aware that the water damage limit at the time you signed the application for insurance policy 4, admit that the water damage limit under the policy is $75,000. 5, admit that defendant paid the water damage limit of $75,000. 6, that you admit that you replaced items and made upgrades to the insured property that were not part of the water damage. Admit that the majority of the damages to the insured property were caused by contractors you hired, and admit water damage limits of $75,000 were paid under the policy. These admissions and many more establish that Januzi was aware of the policy limits when she purchased her homeowner's policy from Workman, and that those limits included a $75,000 sublimit for water damage. They also established that AMCI made payments totaling the $75,000 limit. Januzi's causes of action against Workman for negligence, fraud, and negligent misrepresentation are rooted in her accusation that Workman, an insurance agent, represented that the policy covered her needs fully and that she had the correct coverage. Therefore, the evidence establishes that Januzi was aware of and consented to the policy limits prior to her insurance claim, and Januzi cannot offer any conflicting evidence. The judgment of the trial court below was affirmed, and all of the costs of the appeal were adjudged against Lynette Januzi. In my opinion, deemed admissions are a difficult thing for litigants and must be resolved immediately, or obtain extensions from counsel if you can't answer in an immediate way. When I was a young lawyer, California allowed litigants to deem admitted requests for admissions that were not responded to in 30 days, just like it is now in Texas. I filed on behalf of my clients dozens of motions for summary judgment based on requests that were deemed admitted, and they all resulted in a summary judgment in favor of my clients. The plaintiff, whose case was lost because of admissions deemed admitted, is not without a remedy. Her lawyers who failed to respond within 30 days may be responsible for the error. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,850 blog postings. Please tell your friends and colleagues about the blog and the videos and let them subscribe to the blog and the videos. And if you do watch the videos, please click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.